Senator, Mr. Sherman, when I heard them describe your background, it involved some work on Capitol Hill, did it not, with the House Ethics Committee?
Correct.
So let me give you a hypothetical and see if you can help me get to a conclusion. Let's assume that, like the Supreme Court justices, our congressional recess starts somewhere in August, and a really good friend of mine of many years decides that he wants to pay for my wife and myself to first fly on his charter plane to a distant destination and then spend a week or two on a very palatial yacht of his. And then he'll return me home after I've had my vacation. What kind of responsibility do I have as a member of Congress to disclose any of that?
Well, I think the first requirement you would have is to call the committee to seek approval to accept the travel in the first place. But then you would have to disclose the travel itself, if you were approved, the travel itself, the amount of the travel, and the source of the and who funded aspects of the travel.
When you say disclosed, do you mean publicly disclosed?
Correct.
So let me ask you if you know what rule would apply to a district court judge, a federal court judge, who had the same opportunity.
In the federal courts, my understanding is that there is less disclosure requirement with respect to privately funded travel. And at the Supreme Court, the personal hospitality exception would cover a lot of this depending on the nature of the friendship, and it wouldn't have to be disclosed at all.
So there'd be no disclosure in the district court level or the circuit court judges?
I believe there would be.
There would be disclosure.
Yes.
And they have a code of ethics as well?
Yes, they have a pretty lengthy binding code of ethics. The Supreme Court does not, though they say that they sometimes reference the former.
So Justice Thomas, when he did not disclose at the Supreme Court level, was he in violation of any law that you think applies?
Yes. So with respect to Justice Thomas, while personal hospitality need not be disclosed, there is a requirement if you're staying in somebody's home, for example, you share a meal in their home, but the payment of his actual travel to the location on the private jet, his travel on the boats, especially because that travel, as we understand it, was funded by a private company and not actually the hospitality of Mr. Crow, needed to be disclosed and was a violation of federal law.
Professor Sample, I'm trying to wrestle with the argument we hear from the other side that this separation of powers gives Congress little or no authority over this court created by the Constitution, as opposed to the inferior courts. And yet, when you made reference to 28 U.S.C. 455, this was one of the federal statutes enacted by Congress to apply to the Supreme Court, which apparently the court at least nominally follows. Is that correct?
Correct.
Can you rationalize that thinking that Congress has no authority over the court, and yet the court follows what Congress says it should?
I think, Senator, it's clear that Congress does have authority to regulate the Supreme Court. Indeed, separation of powers doesn't mean that one branch of government is entirely independent of the others. Congress regulates many aspects of the Supreme Court, including the size of the court, the salary of the justices, its budget, the quorum requirements. As far back as the Judiciary Act of 1789, Congress has been in the business of making manifest the Article 3 promise that there will be a Supreme Court, but without Article 1 legislation that this Congress can pass, that Article 3 promise would be a parchment promise at best.
I'm sure I'm not saying this as they would, but those on the other side argue that Congress has authority when it comes to those elements you've just mentioned, but doesn't have the authority to impact the decision-making of the court. They draw that line. Do you recognize that same distinction?
I think, and in the prior hearing, Professor Amanda Frost did a nice job, in my view, and her written testimony does a nice job laying out the key core of the judicial process is the power to decide cases and controversies. And so a decision that intrudes on the core decisional independence, in the case of Smith v. Jones, say, if Congress were to say that Smith has to win and Jones has to lose, that's a real problem. That's an intrusion into the core of the judicial power. The legislation that you and your colleagues have proposed does not intrude into that core decisional independence in any way.
Thank you. Senator Hirono?